All right, thank you for the introduction. I hope everybody can hear me. My name is Ed Chaney, and I'm joined with by my colleague Peter Mattocks. We are with the firm of Schell Bray. We're based out of our Chapel Hill office, and our practice area um, focuses on advising nonprofit organizations on the various tax and corporate things that they might be dealing with from beginning to end and everything in between. Um, we are here. Well, let me actually back up and first say thanks to the Pro Bono Resource Center and the Governor's Commission on Volunteerism for pulling this together. This is a wonderful thing for the sector to have. A wonderful resource. Both organizations are a wonderful resource, and to provide this as a platform is a great thing. I know that Peter and I practice, all of our clients, or almost all of our clients, are nonprofit organizations, but and there are only a handful of attorneys, I think, that practice in this space all the time, like Peter and I, statewide. But there are many, 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 many more nonprofits than we can serve, many of whom cannot afford the representation and look to folks to provide them pro bono service. And we're always happy to answer questions if there's a particularly vexing question or anything like that. So with that introduction, I'm going to, and I'll let me say one more thing before we move on, is that today's session is the first half of two parts. And I'm going to lead today's session, and Peter is going to lead the sort of follow-up session next week. There's just a lot of room to cover if we're going to talk about how to deal with a crisis situation if you're a nonprofit. So we had to break it up into two sessions. So with that, I will share my screen and start going with the presentation once I can. So over the course of these 2 days, these 2 hours over 2 days, we're going to cover the governance considerations around dealing with a crisis, the issues around financing your organization during a crisis, which most frequently come down to how can you tap into donor restricted funds and grants. Those are probably as far as we will get today. Next week, we will cover operational issues that arise during a crisis, and then heaven forbid that you have to go down the path of terminating or restructuring as a result of the crisis. We will talk about some of the issues that arise then as well. So I want to start off with a conversation about governance, because at the end of the day, when an organization is in crisis, it is not singularly a management issue. It's not singularly on the executive directors or the development director's plate. It is a organization-wide issue. But first and foremost, it's a governance issue and a management issue together. The ultimate responsibility for a nonprofit organization lies with the board of directors, and that board must be actively engaged. The board of directors cannot delegate its fiduciary duties away to the management team, but they can delegate the tasks of management to the management team. Oftentimes, when an organization is in the place where it is in crisis, it is because there's a breakdown on one of these two sides. Typically, it's the governance side of things. As you can imagine, nonprofit boards are filled with volunteers that are very well-meaning. They may be community members, they may be very busy professionals, but at the end of the day, they're typically all volunteers, and may not sort of appreciate or understand their roles in an organization and managing an organization. And dealing with reframing the crisis to be one that must be managed actively by the governing body as well as management is really the first task that outside counsel usually faces. This isn't always the case, but it is often the case. So I'm going to go through some really high level basic governance 101, nonprofit governance 101, to kind of set the stage and discuss some of the things that might come up in the course of dealing with the governance as an issue. And so I'm going to start with talking about just sort of what are the roles, the general roles of a board of directors. If you asked 100 nonprofits in North Carolina, what is the number one role of a board of directors, the very first thing at the top of that list would be fundraising. And practically speaking, or the way it plays out, that is often true in terms of what the organization needs from its, and particularly what the management needs from its board. They need access to capital, they need people to open doors for them and raise money. And it's really hard to do that just as staff when you're trying to manage the programs, and you may not have the same access as that your board may have. And so frankly, many boards of directors are oriented in that direction. But when it comes down to it, the board is responsible for the overall management and operations of the organization. And so when I list out the key roles, I drop down fundraising down to 5 or 6 or something like that, because there are a whole host of other things that often get overlooked. Those include selecting, establishing the compensation of, and managing and evaluating the executive director or CEO, president, or sort of whomever that primary staff person is, setting the vision for and planning, setting the vision and planning for the direction of the overall organization, monitoring that plan vis-a-vis the mission, providing good financial and other oversight, and then that includes helping to secure the needed resources to do that, managing risk, advocating for the organization, and evaluating itself and planning for succession. When it comes to an organization that is operating in crisis, all of these, not necessarily all of these things, but a lot of these things are going to be in play. Managing how the staff is handling the crisis, setting the vision and planning for how we're going to get out of this crisis. That should not be driven by the staff. That needs to be driven by the board in partnership with the staff. Monitoring how that is happening, and then providing the financial oversight that's going to be necessary to sort of monitor that plan, and raising the money to the extent that you can. The board of directors is a fiduciary body, and that means that it under the law, it has ultimate legal responsibility for the organization, and that is operationalized by these what are called fiduciary duties. Duties are the standards by which board members are judged in carrying out the roles that we previously talked about. They are not actually the roles, they're the standards for the roles. And there are 3 primary duties, fiduciary duties: the duty of care, the duty of loyalty, and the duty of obedience. We're going to spend our time mostly on the duty of care here, but it's worth talking about the other 2 as well. The duty of obedience is the organization's, the director's obligations to be true to the organization's mission and its governing documents. The duty of loyalty is to put the interests of the organization above one's own personal interests. Typically, that relates to economic interests, but not exclusively. And then the third is the duty of care, which is your responsibility to carry out your role in good faith, with the care of an ordinary prudent person who would, in a like position under similar circumstances, and in a manner that the director reasonably believes to be in the best interests of the organization. And the important thing about the duty of care is that in discharging it, the more consequential the decision, the more care, the more diligence is required. It's really easy to carry out the duty of care in simple circumstances, but if it's in the case of an organization in crisis, just showing up to a meeting isn't necessarily gonna be enough. They've got to ask the hard questions, analyze the data, look at the metrics, all that sort of stuff. It needs to be done by the board members to fully discharge their duty of care when you're in a situation like that. So, with that framework, we've talked about what is the board's responsibility. Well, management also has responsibility here, and the management is effectively let me back up for a second. At a high level, the board of directors is the governing body of the organization, but individual board members do not have the agency to act on behalf of the board unless they are officers of the organization. And the officers of the organization, in fact, that's why they're appointed. They're appointed to be the agents of the organization that carry out the direction and vision of the organization under the supervision of the board. Sometimes those managers and officers can be board members. Most oftentimes they are, most oftentimes at least, the CEO is or the executive director is a staff person and not a board member. And typically management is constituted of the CEO, maybe the CFO if there is one, a board treasurer perhaps, but sort of the 2 or 3 key officers, which may be a mix of directors, maybe a mix of directors who are serving as officers and as staff members. So in that partnership between staff and management in carrying out the managing of a crisis, the board needs to, on its side, get in front of insolvency. Like, this is how it's going to discharge its duty of care. It's going to need to sort of determine key metrics, look at sort of key timelines and decision points that are going to have to be made to sort of figure out how they're going to weather the crisis, if it's an economic crisis or if it's some sort of other crisis that's created by a disaster. They're going to be the ones that are going to have to ask the tough questions and make the tough decisions, and then provide management direction and oversight as they carry out those tough decisions. On the management side of things, in order for the board to be able to discharge its duty, to do what it needs to do, it needs to be fully informed. The management needs to open up the books, be bluntly honest with the organization, with the board about where the organization is, where its potential liabilities and risks are, what's its bank account look like, all those things. But it should also provide thoughtful analysis in taking a look at these things and proposing solutions to the board, not just sort of dumping this information and saying help board. You don't see that happen very often, but you do see it from time to time. Keeping in mind that management is typically the paid professionals and the board are typically the community volunteers. The management's role in really thinking about this and proposing solutions and doing analysis is really going to help the board go a long way in making good decisions. And of course, the management's duty is to carry out the board's decisions, not carry out its own decisions or contravene the board's decisions. From time to time, you may, as I mentioned, have a situation where a director is also an officer or an officer is also a director. For instance, the executive director may from time to time serve as a member of the board. There is no legal prohibition in North Carolina that a paid staff member, the CEO, cannot also be a board member. I think generally speaking, most people feel it's a best practice to keep some separation there, but that isn't always the case. There can be good reasons to have the executive director be also a board member if the checks and balances are in place. So if you come into a situation like that and you're the outside counsel providing advice, it's something that you need to be aware of, and how those dynamics can play out. And these dynamics can be particularly acute in a situation where the executive director is also the founder of the organization. This organization is their baby. They've built it. They built the board around them. It's their vision. And they've coalesced a lot of power. Keep in mind that oftentimes, again, when an organization's in crisis, it has gotten to a point of crisis because there has been a breakdown in governance, and there is a large Venn diagram of breakdown of organizations that have a governance breakdown and organizations that are really still under the grasp of an entrepreneur, because there is so much deferring to that entrepreneur, to that individual, to that executive director, and so one dynamic that counsel often has to deal with is sort of how to pry power away from that executive director and get the board focused on in its independent role. And again, number one is that the officers are agents of the organization, and their delegation comes from the board. They don't have a role to act independently or make their own independent decisions. And sometimes that it takes a while for the entrepreneur executive director to understand, and for the board to understand, for both sides of that to understand. And sometimes it can be useful in managing the situation for the board to call executive session and ask for that person who's serving in the dual role to leave for the sake of independence, particularly if there's an economic conflict involved, such as the compensation of the officer, which very well could end up being an issue when you've got an organization that is in financial crisis and staff salaries comprise a substantial portion of the overall budget. Again, the board needs to be careful proactively not to cede its overall governance authority, to the extent that they already haven't done so. And this also, this often requires education of both sides of this, both management and directors. And almost without fail, conversations in crisis and when boards are looking at their balance sheets and looking at whether they have to lay off staff or dissolve, or how did we get here, what's going on, questions like, am I going to be on the hook here financially speaking? Am I going to have to contribute assets to this organization to keep it going? Generally speaking, the answer is that in North Carolina, and really in most states, the liability protections for volunteer directors are really strong. Generally speaking, you are really well insulated. In North Carolina, there are a few things that you need to be aware of, and it really those protections come down to what are the statutory limitations, what are indemnification provisions, and what are your insurance? What does your insurance look like? So I'm going to talk first about what the statutory provisions are so that you are aware of them. There are two different ones in the statutes. The first is in 55A, which is the North Carolina Nonprofit Corporation Act, is 55A, -2-02B4, which provides the option for nonprofit organizations to insert language in your articles of incorporation that eliminate personal monetary damages for directors only for directors, not officers, for violations of their fiduciary duties. So if it's in there, and the I mean, and there's some exclusions for that for really bad actors and things like that, but generally speaking, if there's a violation for fiduciary duty, the directors are going to be off the hook, but it's got to be in the articles of incorporation. Then later in 55A, in -860, there is a general immunity provision for officers and directors for monetary damages that arise out of civil liability. It only applies to the extent that insurance does not cover the act, right? So if there is some sort of negligent act or something like that that causes a civil action and the directors and the officers get sued, the only recourse for the plaintiff is the extent for the individuals, as to suing the individuals, is the extent to which insurance may cover them. This only applies if you are not compensated as an officer or a director. And this is one of the key reasons why it is always good to have volunteer directors and not compensate your directors, because if you compensate them, you then waive this this immunity provision. And this is generally an application of the general volunteer immunity that is provided elsewhere under North Carolina law, which applies to just volunteers in general and not just fiduciaries. So if, I guess an additional protection, North Carolina nonprofit corporations and boards are afforded the best judgment rule, the business judgment rule, whatever you call it, and that is if you carry out your fiduciary duty of care and loyalty in making a decision, a court is not going to second guess your decision and hold you liable. But so what it typically comes down to is in North Carolina, because of these immunity provisions and exculpation provisions and the best judgment rule, generally speaking, the expenses that directors have to look at relate to their defense, because it's still, it's still got to be dismissed, it's still got to be litigated, and through motions practice and all that sort of stuff. And sometimes you go through discovery and things can be pretty painful and whatnot. So North Carolina, as every state, permits the organization to indemnify the directors and the officers, meaning that they step into their shoes in terms of the financial payment of that defense. And there's North Carolina provides mandatory indemnification for any case in which a director or officer wins, but also permissive indemnification in other instances, provided that there is that the conduct of the officer or director meets a certain threshold, and it also permits the advancement of expenses. But there's also a specific process that the board has to go through. So at the end of the day, the question is, what do your bylaws say about indemnification? Is it narrower or as broad as statute? If they're silent, then you can fall back on the statute, but you could have bylaws that are not poorly drafted rather, and are more limiting than they could be. But here's the thing, an organization that's in crisis is not going to have a whole lot of resources to indemnify with, and this is where insurance is really important. And there's going to be a whole nother section on insurance I think actually immediately following this session. So I'm just going to touch this at a high level. You want to make sure that the organization has directors and officers insurance plan, as well as general liability and things like that, so that if indemnification is needed, the insurance policy will cover the expenses to the extent that the organization does not have them readily available. So now I'm going to pop on to sort of the next topic, and I'm going to reserve some time to take questions at the end if there are any. The next section that I want to talk about is relates to, because oftentimes the first question you get is, or you should be asking, is where is the board in managing this crisis, in helping the board sort of realize what needs to happen, and setting the stage so that they can manage this crisis in a way that fulfills their fiduciary duties. The next question usually comes to, well, can we spend all of the money that we have for to manage this crisis? And so for those of you who are sort of seeped in the financing of nonprofit organizations, most charities, not all charities, are primarily funded through donatives. People give them money to fund their donations. I mean, to fund their operations. Now some nonprofits also have enterprises that earn revenue and offset their expenses and things like that. But by and large, nonprofits rely on the generosity of their individual and corporate donors, including private foundations and things like that. And in that world, nonprofits have funds that are restricted and funds that are not restricted. And unrestricted funds are, nonprofit can spend for whatever purpose they need, but restricted funds can't be spent for whatever they need there. And I'll talk about that in a bit. But what often happens is that unrestricted funds get spent down first, and people are looking at their balance of funds that are restricted and wondering if they can spend this restricted reserve or restricted program over here for general operating to get it through this crisis. So to back up here, just put this in a context of the law. The donor this notion of a donor restricted fund relates back to old trust law. That is, when a donor gives something to charity, when that donor gives something to charity, they impress it with aspects of a charitable trust. And what that means is that the organization is legally obligated to spend the money consistent with the purposes, the charitable intent of the purposes of the gift. And it's not just purposes. There are really two kinds of restrictions that well, there are really three, but two most important restrictions that donors can put on funds is a purpose restriction. I am giving you this money, but it's to be spent on this program, or to be spent for this particular purpose, or this particular aspect of your activities. And when you receive that, it becomes a restricted fund, and you have to spend it for that purpose. The other type of restriction is endowment restriction. And this is when a donor gives you money and says, here is $100,000. You can't spend it, but you can spend the income off of it in perpetuity. And so you've created an endowment, and you invest that money, and then you spend the income from that. Now, donors can also put kind of process restrictions around a gift too. Say they create a scholarship fund and say, I want the scholarship to do this, but I want, X, Y, and Z criteria, and I want the process to be, draw from these people and selected by this committee and all that sort of stuff. Those are also sort of restrictions as well. they're a little easier dealt with, but they also aren't the ones that typically matter when it comes to the point in time of an organization dealing with a crisis. Those restrictions that we're talking about here can be released. They're not necessarily stuck there in perpetuity, but the law provides very specific ways that those donor restrictions can be released. And these are all contained in what is called the Uniform Prudent Management of Institutional Funds Act, UPMIFA, which is adopted in every state but Pennsylvania. And Pennsylvania didn't adopt it because they already had a very similar law on the books. And in North Carolina, it's 36E. And it provides that a donor restriction can be released by the donor if the donor gives consent. But know that if you have a fund in which you have collected a lot of donors, you can't get consent from one of those donors to release the restriction on all of the other donors. You're going to have to, unless the fund document that initially created, say it's an endowment, it was created by one donor and said if anybody contributes to this, it's going to be governed by this document. Outside of something like that, you're going to have to reach out to all of the donors to get that consent. Another way to get a restriction released is by doing a Pray process, and this involves taking a petition to court saying why the funds can't be spent in the way that they were given. And there is a standard you have to meet. It has impossible, impractical, or there are a few other sort of things that you have to meet. It has to be one of those things in order for you to be able to go to court and say we can't spend it because it is X, Y, or Z, and we want you to release the donor restriction. But it's called Pray because that is Old French for as near as, and so you can't just sort of release it and spend it willy-nilly. You actually have to apply or come up with another way to spend the money that you're able to, that's as near as to that initial donor intent as possible. There's another similar court proceeding for what's called modification. The standard for modifying a fund is lower than the Pray standard, because Pray is about the purpose. Modification is about these other sorts of process restrictions that might be part of the fund that I talked about. And there are certain small funds that if they're old enough and small enough, you do not have to go to court to release the restrictions. You do have to notify the Attorney General that you are doing, that you're going to release the restriction on your own. But those funds are it's a pretty narrow band of funds that are eligible for that type of modification or Pray. And I should say that if you in North Carolina are operationalizing a Pray or a modification action, you do have to provide the Attorney General notice of that, and the Attorney General doesn't have to approve, but they can object. And if they do object, they're kind of putting you on notice that if you proceed forward, that they may bring a fiduciary duty suit against you. So let's talk about endowment funds for a second, because one thing that I have seen a lot of this year among my clients and in the general public and Twitter sphere, sort of among commentary, is why are nonprofits, particularly, I see this a lot with universities and things like that, but why are nonprofits suffering right now? They're sitting on, trillions of dollars of endowment funds. Why can't they just tap into them? And the reason why you get that question is that there are three common public misperceptions. One, that an organization's endowment is a single thing, when in reality, it's not. Every fund that is restricted by a donor is a separate endowment fund. Now, all of those things may be commingled and then invested for endowment purposes, or for investment purposes, or an organization may also dump its reserves in there and sort of call all of that stuff its endowment. But from a legal perspective, The endowment is actually that fund, each one of those funds. The other common, the second common misperception is that it's a rainy day fund. The public, I think, or some members of the public sort of think of endowment funds as reserve funds that are invested, and that's not true. Again, it's typically a fund that has been given to the nonprofit by a donor or generous donor to carry out a specific purpose, to carry out a specific activity. And the reason why it's invested is because they want the nonprofit to be able to carry out that activity over a long period of time. It's not invested to be a reserve fund. It is meant to set that organization's activities up for the long haul. And similarly, sort of for similar reasons, the public thinks that, or some members of the public think that you can just sort of plug your budget gaps by tapping into your endowment. But budget gaps or things like that do not excuse adherence to donor restrictions. UPMIFA also governs, a different section of UPMIFA governs how much of an endowment an organization can spend. And the whole rationale of UPMIFA's spending provisions around the endowment are to protect the intent of the donor in creating this perpetual endowment to fund that activity over time. And UPMIFA's, the legislative history of it, and it's a model act that got adopted around, and the commentary around that makes it clear that they just don't mean sort of the original corpus that was given to it, but also the purchasing power of that contribution over time. So you're looking at inflation adjusted purchasing power of the entity, or excuse me, of that particular fund. And UPMIFA is just as strict about the purpose restrictions as it is the spending restrictions around endowment funds. So whether you're in a bull market or a bear market or the budgetary crisis, under UPMIFA, the standards are the same. You can only spend funds to the extent that they are prudent. And what typically happens is that an organization adopts a spending policy and says, I'm going to, we're going to draw down 5% of the fair market value of the investment assets. And that's what we mean by income. And we think that's prudent under these facts and circumstances, and that's what we do. And every year, sort of the board revisits that percentage. They can get very complicated and messy, but that's sort of the typical one. And when the board adopts a spending policy, it's supposed to be looking at the duration and the preservation of the endowment fund, the purposes of the fund, the general economic conditions, the possible effects of inflation, deflation, the expected total investment returns, the other resources of the institution, and the investments policies of the institution. So there are factors in here that can weigh in favor of larger distributions in times of crisis, but the touchstone of UPMIFA still remains the duration and the preservation of the spending power of the endowment fund over time. So, I've helped a number of clients this year step back and take a look and say, well, first thing, given that you can't just raid this endowment fund, let's actually make sure it's a true endowment fund. A true endowment fund is a fund that was created by the donor. The donor was the one who said you cannot spend this money. And that needs to be in writing somewhere. There needs to be a gift instrument that is in writing. And that writing could be from you saying, we want to create your donor, we want to create an endowment fund, please send us $100,000. And the donor says, in response to your letter, here's $100,000. That's enough. It could be in emails, but hopefully it's in some sort of gift document, some sort of gift instrument that says, I hereby am creating this fund for these purposes. It's to be an endowment fund, yada, yada, yada. Absent that stuff, you got to wonder, is it really an endowment? And oftentimes the answer is no. The board was populated by people who sort of had this conception that, you know, an endowment was a reserve fund or things like that, or they decided they wanted to treat it as an endowment fund. But you'd be surprised at the number of organizations who discover money because they thought they had an endowment, a true endowment, when actually they did not actually have an endowment fund. And oftentimes you can find, well, not oftentimes, but occasionally you can find some helpful language in the gift agreement, where the board is given permission to spend, to modify the gift instrument on its own, things like that. If not, you know, see if you can get the donor to consent to the change of the purpose or to release the endowment restriction. Um, if you can't do that, you know, has the fund itself kind of accrued some spendable balance over time? Like, you know, has the organization not spent, has the organization underspent the endowment over time, such that its spending power now well exceeds the spending power, the purchasing power of the original contribution? If the answer is yes, then you've got, again, a little bit more flexibility there to pull some down. And finally, if you know, if the purpose of the fund is still achievable and appropriate, you got to keep, you can't go to court. But if it's not, then perhaps this is something that you can take to court to get released. And again, you'd be surprised how many funds, or how the amount of funds that can be kind of freed up in doing a fund by fund analysis of your endowment funds. Now, unfortunately, this is an exercise that only the privileged nonprofits can really undergo. I mean, you know, the nonprofit sector in some way kind of mirrors the wealth gap in among individuals in America, where smaller percentages of nonprofits hold a greater proportion of the assets than most, you know, most of the organizations in the state and really nationwide. But you may be in a position where this is a relevant analysis in one form or the other. The last thing, I'm going to check time here because I do want to save some time for some Q&A. You know, I think, you know, there are ways for those of you who are working with nonprofits now. There are ways to do like an audit of your organization, to take a look at the way it raises money, the way it's documenting gifts, etc., to see if it's got, if there are ways that it can reform how it does stuff in order to give it some flexibility in a future crisis. I mean, you know, we're on the tail end maybe of the COVID pandemic. You know, we'll sort of see what happens here. And, you know, the nonprofit sector was hit hard, but there were a lot of organizations have weathered the storm in part because of the support that the governor's office has provided, as well, and the PPP loans and some generous donors. You know, we may be sort of on the backside of this, and at least hopefully at some point we will be, and it will be a good time to take a look at what types of policies that you have in place. You know, is there a gift acceptance policy over what kind of restrictions that an organization will accept? You know, can you encourage unrestricted funding as part of the restricted funding? How are you keeping and maintaining records and things like that? And finally, last thing I'll talk about here is that, you know, a lot of funding in the nonprofit sector comes from individuals, but a whole lot also comes from grants from private foundations, whether those are family foundations or from corporate foundations, and from, you know, to some extent, donor advised fund providers and community foundations and public charities that make grants. These grants are a little bit different than than that sort of previous regime when I talked about a donor giving you a charitable gift. They're often more appropriately viewed as enforceable contracts with a grant agreement, a grant between two nonprofits. This nonprofit is funding that nonprofit to carry out these activities under this grant agreement. But at the end of the day, you kind of have similar issues. The grant agreements are restricted for the purposes for which they were given, and if you can't do that, what are you stuck with? And hopefully your funders at that point are going to be flexible enough to renegotiate the terms or to lift all restrictions or to provide some other additional support for general operations so that this other program stuff can carry on. Worst case scenario, you might have to cancel the grant agreement if you can no longer afford to carry out that program, and the donor's not interested in renegotiating, and that might require the repayment of funds that have not yet been spent. But at the end of the day, you've got to go back and look at the grant documentation. And I think an overarching consideration here is that this is as much a sort of legal issue as it is a donor relations issue. Oftentimes these donors have been these funders have been longtime funders, and will be there for you if you can weather the storm. So relationship-wise, what's the best way to handle this, sort of going after an aggressive legal position for the sake of expedience, say the grant agreement is poorly written or something like that, it may present a nice opportunity to spend some money that you might not have had, but then you've got to ask what are the costs of that as well. So with that, since I don't want to dive into operational issues with 10 minutes left, I will stop for now and see if we have any questions.
Hey, Ed, so we do have one question here. What role should the board or management hold in pursuing relief granted by legislation around COVID-19?
So the board really needs to be involved in that, because particularly when it comes through loans that are coming through the SBA or things like that, they require board resolutions. So the management can, sort of take the lead on sort of investigating those things or whatnot, but the board needs to be aware of what's happening. At the end of the day, is going to have to pass resolutions to accept those loans. The PPP loans are hopefully going to be forgiven. Most of my clients that have gotten the PPP loans are in the process of being forgiven, but there's a lot of mystery sort of going on there. There are other loans that are out there that are not necessarily going to be forgiven, but they're low interest loans. They're meant to provide some disaster assistance. These programs are also run through the SBA. The question that you have to ask there, if you are a board, is what are you borrowing against? And how are you going to pay that loan back if it's not going to be forgiven? It's still a low interest loan, but are you borrowing $40,000 at 2.7%? You're going to have to repay that amount. You're borrowing against future something. Are you borrowing against future fundraising, or are you borrowing against future earned revenue? What is it exactly? And if you don't sort of think that through, you may just be punting the ball on insolvency. So that's an important role for the board to consider.
All right, and there's actually two more questions. So there's a follow-up question to that one, and then another one. Is the level of diligence required for the board given a safe harbor by necessary quickness due to an emergency? So are there any forgiveness if you need to do things quickly or make these decisions quickly because of the emergency nature of them?
Sure. Yeah, I mean, I think the standard at the end of the day is what would a reasonable person do under like circumstances, and an emergent situation is going to be factored in there. You still got to do your diligence to the extent that you can within that reasonably that you can within that framework, but sure, that is a factor.
All right, and then there's one more question, sort of a general advice question. So if you have a nonprofit that has received a grant or funds and restricted funds in some sense for them to do programming, so not in the situation where they're trying to respond to COVID, but they're unable to do that programming. Like this personally happened to me, unable to do that programming due to COVID. What do you suggest they do? How do you guide clients to approach their funders, and how do you ask those types of questions? If that's
so let me reflect that back to make sure I've got it clear. You're running a nonprofit to do X, Y, Z in the community. You've gotten a grant from Z. Smith Reynolds to do part X. COVID has shut that down for whatever reason.
Right, and you can't do it.
Yeah.
Or you have to you'd like to modify it.
Yeah, I mean, from my experience, the funders have been very understanding of the situation, and phone call number one is, well, conversation one is with the board and say, hey, look, this is what's happening. Have some conversation about the strategy there, and maybe your board members have some inside connections or things like that, and if so, use that. But if not, phone call number one is to program officer who you worked with to get the grant to say, hey, look, we had a 2-year grant to do this. We lost a year because of the pandemic. Can we just extend this by a year, or can we reallocate some funds, because in this initial year, in this crisis, we now have this other issue that's really pressing in the community and it needs immediate fixing. And I just, if when a funder is not willing to play ball, it is often because their purposes are really narrow, or their programs are really sort of narrow, and there might be a legal reason why they can only fund this type of activity. In which case the conversation becomes, how long can I keep the funds to restart that activity, or whatnot. But generally speaking, the funders are going to understand, particularly in this climate.
Okay, got it. I think that is, let's see. No, it looks like we got one more question. Do you have time for one more question? Is that all right?
Sure.
Okay. If donations are given to help meet the needs brought about by an emergency and more is raised than needed, what happens to that overage?
Yes. So
luxurious problem, we'll call it.
Yeah. And historically, we've seen some very high profile cases following the Boston Marathon, following 9/11, following some high profile hurricanes. Various organizations ended up raising a lot more money than they needed. We can actually, I'll talk a little bit about that now, but we're in the operational issues section, we actually talk about disaster relief provision. So we can sort of integrate a little bit of this discussion into that section as well. But at the end of the day, if you have money, well, first of all, when you out raising money for a disaster relief, it should be done in such a way that it's understood that you are raising money for disaster relief generally, and that you're going to apply what you need to the current disaster, and what isn't then applied, you will then keep for those purposes for future disasters, or something like that. There are ways to frame it. It kind of depends on how you're raising money and for what purposes, but there are ways to both frame kind of the fund documents around the fund that their folks are giving to, and also your PR. To the extent that you raised money for COVID relief, and money is kept in, and you raised $20 million more than you needed for COVID relief, and miraculously we're all better in 2 months. What do you do with that $20 million? Do you give it back? Do you do whatever? I think that is a tougher situation. That is a situation where you could go to the Attorney General and say, look, we raised money a little bit too narrowly here. and our needs for COVID relief are diminishing, but we're expecting to have future disasters. Can we reframe the purpose of this fund and these donations to be used for broader purposes? Attorney General will say, yeah, no, I agree, and then you go to court and get a cypre action based on that purpose. There may be other ways of solving that. I think it's worthy of having some board discussion around sort of how you handle your good fortune in the midst of bad fortune, because you also have a number of PR issues there. The organizations that raised more than they needed to after 9/11 got really hammered in the public, but there was also some limitations that the IRS was putting out there about how they could deploy that relief, and unfortunately, some of those issues are still a little hazy.
Got it. Well, thank you. I think that is all the time that we have, but I personally look forward to the next week as someone who does a lot of work in that realm. So thank you on behalf of everyone today, Peter, and I know we'll see you more next week. And Ed, we really, really appreciate it. And to everyone who is watching, I think we'll give you a 5-minute break, so you get a little stretch break if people need it, to get up, and we will start our next section with Professor Hornstein in 5 minutes. So thank you to everyone. And Peter and Ed, thank you so much. I really appreciate it.
Yeah, thank you all.